Hi everyone, welcome to my video on the Prevention of Corruption Act. The Prevention of Corruption Act is a landmark piece of legislation that was enacted to combat corruption in government agencies and public sector businesses in India. It is a comprehensive law that covers a wide range of corrupt practices, including bribery, extortion, and criminal misconduct. The PCA was enacted in response to the growing public concern about corruption in India. In the 1980s, there were a number of high profile corruption scandals that shook the public confidence in the government. The PCA was seen as a necessary step to address this problem and to restore public trust in the government. The PCA has been successfully reducing corruption in India. However, it is important to note that corruption is still a serious problem in the country. The PCA is a complex law and it can be difficult to enforce. There is also a lack of awareness about the act among the general public. In this video, I will provide a detailed overview of the PCA. We will be discussing the different type of corrupt practices that are covered by the law, the punishments for corruption, and the procedures for reporting and investigating the corruption cases. I hope this video will be informative and helpful. I encourage you to watch the entire video and leave a comment if you have any questions. The Act was promulgated on 9 September 1988, mainly to consolidate and amend the law relating to the prevention of corruption and for matters connected therewith. The Act was further amended in 2013, 18, and 2021. The Act is in force for the last 3 decades, and ratification by India is done by or done of UNCAC, the United Nations Convention Against Corruption, the international practice on treatment of offense of bribery and corruption. This act is for the whole of India. Coming to the highlights of the Amendment Act, the Act had only few words defined in it, as mentioned in Section 2A, 2B, and 2C. Section 2AA and Section 2D was inserted in the amendment year 2018. Section 2AA defines prescribed, which means prescribed by rules, and Section 2D defines undue advantage, which means any gratification, whatever, other than the legal remuneration. That is a salary. Coming to Section 3, which is regarding the special judge. Section 3 of the Act gives powers to central and state government on the appointment of judges to try any cases under the statute. It also specifies the offences which may be dealt by these judges and what the minimum qualifications should be on appointment. The state and the central government may, by notification in an official gazette, appoint as many as special judges as may be necessary for such area or areas or for such a case or group of cases as may be specified in the notification. To elaborate it, for example, during an election process, each and every legislative assembly is appointed with a special judge. So you can understand what will be the number of special judges that is required to be appointed. Again, coming to the appointment, he should be at least a session judge or additional session judge or an assistant session judge. which is under the Criminal Procedure Code of 1973. Again, Section 4 says that the offences under the Act be tried by special judges only, and a few rules are laid out for that, where it is to be conducted day by day, where the period should not exceed a maximum time of 2 years, and if there is an exceeding date, if there is a delay, then the special judge shall record the reasons for the delay, and a maximum period of 6 months may be granted to him up till an aggregate of 4 years. So he may be granted an extension of 4 times 6 months each. The offences and penalties that are mentioned in the Act. Offences means where a public servant is being bribed, the public servant is taking bribe, some undue advantage is being taken from the public servant, the public servant is taking an undue advantage on his colleagues. All these are kind of offenses. So Section 7 says when a public servant is bribed. The same case, 7A is taking undue advantage of the public servant. Again, Section 7B says obtained or accepted or attempted to obtain undue advantage from any person as a reward for improper or dishonest person of public duty. Again, the person who is being mentioned here is a public servant. It is not compulsory that you take some undue reward or undue advantage, but you even tried to do that. For all these things, as per Section 7, your punishment is 3 to 7 years of imprisonment, and where you are also liable for a fine. The word fine is clearly mentioned in Section 16 of the same Act, where we will be coming again. The next slide. Section 8, where any person gives or promises to give an undue advantage to another person to induce a public servant to act illegally, you have 7 years of jail. Offense relating to bribing a public servant by commercial organization. So what is a commercial organization? Any business organization. Any business organization. Let it be company A or a partnership firm B or a joint stock company. Anything. They are punishable with a fine. Again, they are punishable only with a fine. They don't have any jail term. Where person in charge of a commercial organization. Here, a person is being mentioned. Where a person in charge of a commercial organization, like the director, the manager, the secretary, or any officer of that organization is found guilty of an offense. In that condition, he may be given a jail term of 3 to 7 years, and he is also liable for a fine. Section 11. Public servant who is obtaining an undue advantage without any consideration from the person concerned. Here, the public servant is being put in question. Uh, till the previous slide, here the public servant was being given a bribe. So the person giving the bribe is being given a penalty. In this slide, it is a public servant who is doing the offense and who will be given a penalty. In this case, Section 11, 6 months to 5 years is what the period of punishment can be. And he is also liable for a fine. Punishment for abatement of offenses. If the public servant is thinking or trying to do some offense, he can be given an imprisonment of 3 to 7 years, and he is also liable for a fine. Section 13(1)(a) and section 13(1)(b). Again, here clearly it is mentioning about a public servant. So 1A mentions dishonestly or fraudulently misappropriates any property entrusted to him as a public servant or allows any person to do so. For example, someone has been given a contract, or the block development officer is having the rights of developing an area for which he is going to give a contract, and he takes some commission from that. That is section 1A. A public servant, now coming to section 1B, 13(1)(b). A public servant is said to have committed offense of criminal misconduct, and he intentionally enriches himself illicitly during the period of his office. Again, coming to the BDO's story, let's change it a bit. The new collector in that area is asking the BDO to do it. He's asking the BDO to do it. In this condition, the jail term is 4 to 10 years. Again, section 14, whenever convicted of an offense under this act and subsequently commits an offense, once he has been convicted and he does the same offense again or a kind of offense again, so he may be punished for a year, for 5 to 10 years. When a public servant tries to commit an offense, just tries to commit, it's not compulsory that he has to do anything. Here he is just trying to do it. He may be punished for 3 to 5 years. All these penalties or punishments are or can be with the fine. Now coming to section 16, where a sentence of fine is imposed under all these sections, right from section 7 to section 15. The court, in fixing the amount, shall take into consideration the amount or value of the property which the accused has obtained by committing the offense. Whatever property has been accrued by the accused is to be taken into consideration. That is how the court is going to fix the amount for the fine. Now, the persons who are authorized to investigate. Investigation is a big process. It is not that anyone can go and start doing an investigation. So, as per section 17 of the Act, persons who are authorized to investigate the case has been mentioned. If it's an inspector only in the case of Delhi Special Police, nowhere else. An inspector can do an investigation if he is from Delhi Special Police. If the case is in a metropolitan area, in that condition, it should be a assistant commissioner of police. In a metropolitan area, it should be an assistant commissioner of police. Elsewhere, it can be done by a deputy superintendent of police. Elsewhere, it can be done by a deputy superintendent of police. And any offense punishable under this act, without the order of the magistrate, these police officers can make an arrest even without a warrant. These police officers can make an arrest even without a warrant. Section 17A was inserted in the 2018 amendment, which specifies the same thing, but even sharply, like inquiry or investigation of offenses relatable to recommendations made or any decisions taken by public servant in discharge of official functions or duties. No approval is necessary in case of arrest of person on the spot on charge of accepting or attempting to accept any undue advantage for himself or for any person. So it's clear. The competent authority shall convey its decision within 3 months, which may be extended for 1 month for any reasons to be recorded in writing. So whenever a person is being arrested, the decision should be given in 3 months, and a maximum period of extension is only 1 month, where the reasons for that being recorded in writing. Power to inspect the banker's book. Now, when you come to corruption, mainly we deal with money, paisa. So all these are through the banks. So in that condition, these investigation officers may inspect any banker's books relating to the account of the person suspected of the offense or just suspected of the offense, and take certified copies of all the relevant entries of the bank concerned, and shall be bound to assist to the police officer. The bank cannot say no. The bank concerned is bound to assist the police officer who has come for an investigation. As per section 18A, this is regarding the attachment and forfeiture of the property. The provisions of PMLA 2002, Prevention of Money Laundering Act, are being used. The provisions of Criminal Law Amendment Ordinance of 1944 shall also apply to the attachment or administration of the attached property. Whenever a property has been taken over by the ED, Enforcement Directorate, then section the provisions of Criminal Law Amendment Ordinance of 1944 shall apply to the administration of those properties. Execution of order of attachment or confiscation of money or property. Coming to appeal and revision. Appeal and revision of the judgments of the special judge lies with the High Court as brought out by section 27 of the Act. The High Court may exercise, so far as they may be applicable, all the powers to appeal and revision conferred by the Criminal Procedure Code 1973 on a High Court, as if the special courts were of a court of sessions, trying cases within the local limits of a High Court. Now, what does this mean? The Court of Sessions, special judge were a court of sessions. What was the minimum qualification for a special judge? He should be a sessions judge or additional sessions judge or an assistant sessions judge. So in this case, the High Court will be taking as the case already was taking place in a sessions judge. So this is called a court of session, trying cases within the local limits of the High Court. Any doubts? Do post in the comment section. Please do like, subscribe, and share. Thank you.